Hello, everyone, and welcome to One Civil Law. And for today's story, we have a spicy decision out of the U.S. Court of Appeals for the Fifth Circuit when it comes to revenge porn photos, videos, and stories. So this obviously has been an issue that has been of increasing interest in the last couple of years, last decade or so. And many states and the federal government have passed laws to make this illegal. And the general idea here is that although you might have had consent at some point in the past to take the photos or to share the videos or to tell the stories, perhaps at some point that consent no longer applies. Now, this is legally tricky, obviously, for First Amendment reasons, because you obviously have a right to speak. And so the exact contours of these laws are tricky on a state level, and they're very tricky from First Amendment perspectives. And so it is quite possible that some of these laws are not necessarily constitutional, or not necessarily constitutional in all applications. So there is still a growing issue in the law regarding the scope of what is permissible when it comes to making this kind of conduct illegal. You know, under what circumstances can you share past photos, past videos, or tell stories of a graphic nature relating to someone that doesn't necessarily involve their consent in the moment? So what are the contours of that from a First Amendment perspective is always interesting. And at least we have one kind of answer for the moment, at least in one context. So which brings us to the United States Court of Appeals for the Fifth Circuit in the case of United States of America versus Mark Uhlenbrock, I guess we're going to go with. Uhlenbrock, what a name. We'll call him Mark. United States versus Mark. All right, Mark, what did you do? And is it illegal? And more to the point, is it unconstitutional for it to be illegal? So that's what we're going to try to find out. Let's do that. All right. A jury convicted Mark of violating 18 U.S.C. 2261A 2B for publishing ex-girlfriend spicy pics and videos and some stories that he wrote in her name. The Court of Appeals for the Fifth Circuit affirms. So we shared some photos and videos and some spicy stories using her name. And he was convicted of violating the law relating thereto. Okay, let's find out a little bit more about exactly what he did. From May to September of 2020, Mark posted the nude photographs and videos of YouTube, of YT, I just said of YouTube. That's her name, is YT. Published the nude photographs and videos of YT, his ex-lover, on Reddit. Like all good things, Reddit is involved. Some of those images she had voluntarily sent to him during the romantic relationship, but some he had surreptitiously recorded. Great. She never allowed him to share any of the media or to post it online. Great. Accompanying some of those videos and photos, Mark shared stories that he had drafted in the first person using YT's maiden name. Neat. They further identified her by occupation, employer, and state of residence. Okay. Writing as YT, he claimed to be an addicted exhibitionist. For example, he stated, "I am a real U.S. airline flight attendant. Here I share clothed naked pics, G and R rated home videos, and erotic stories. You can read about my exhibitionist fantasies." Okay, so we see several problems. It's not necessarily even that he's writing stories about her. He's writing stories as her, which, you know, that's problematic. That could be problematic. So I'm sharing photos and videos, and I'm writing stories as her. Okay, on Reddit. I'm sensing some legal bells are starting to go off in my mind. Danger, danger, danger. Some legal bells are starting to ring. Another post read, "I enjoy stripping nude and self-pleasing for men I've met on my many layovers. It's my favorite way of sexually expressing and satisfying myself. Good. He invited men to look for YT on their flights and to proposition her. Legal alarm bells are ringing in my head. Legal alarm bells are ringing in my head. It's like, I don't. If a client came to me and is like, could I do this? I'm like, let me do a little legal research first. But my gut feeling is, if you're writing stories as her, inviting people to proposition her, in the course of her business and employment and stuff, it's probably not good. There's some civil liability. There might be criminal liability. Let me do some legal research. I'm not sure you should be doing these things. This sounds problematic. A close family friend alerted YT to Mark's posts, aware that 2020 was not the first time Mark had published YT's intimate content. YT immediately started searching for the photographs to find out where they were and how far they spread. She took an entire week off work and spent 8-9 hours a day scouring the internet to find these images to see how bad this was going to be again. She contacted the FBI. Yeah. Okay, what law did you break, Mark? Okay, a grand jury indicted Mark on one count of cyber stalking under 18 U.S.C. 2261A2B, which states in relevant part, whoever, with intent to harass or intimidate, engages in a course of conduct that causes, attempts to cause, or would reasonably be expected to cause substantial emotional distress to a person shall be punished as provided. So essentially criminal harassment. Yeah, I mean, yeah, that seems plausible. Mark moved to dismiss on First Amendment and vagueness grounds. The court denied the motion. Yeah, no shit. No, it's not vague. Broad breath is not the same thing as vague. Breath is not the same thing as vague. So it's not broad and it's not vague. It is susceptible to understanding what we're talking about. And your First Amendment arguments, I don't know. Yeah, I'm not feeling the First Amendment arguments really much, because you have to prove the intent to harass or intimidate. You don't have the right to harass or intimidate to cause substantial emotional distress to a person. That's intentional infliction of emotional distress. And the United States government would like to change that civil tort into a criminal thing, which, if it's not protected for the purpose of civil law, it's not protected for the purpose of criminal law. So, should be fine. Camel Toe $2 says, will this affect Aaron M. Holte and Kayla Ricada? I can't see how. I can't see how that would affect them. But thank you for your super chat. FBI agent Thompson was the first of two witnesses to testify at trial. He detailed his investigation into Mark's 2020 posts after YT brought the photographs and videos to his attention. Thompson identified Mark through IP addresses linked to his Reddit accounts. Thompson then testified Mark had pled guilty in 2016 to violating the same statute through similar conduct spanning years. Amazingly enough, this is not his first time, which kind of really kills the vagueness grounds. Like, if they weren't already dead before, they're kind of dead, Mark. Like, they weren't vague in the first instance, but you've pled guilty to violating this exact same statute before. I had no idea what it meant. Mark, we literally prosecuted you and you literally pled guilty to violating this exact same statute 4 years ago, Mark. You had personal, direct knowledge as to exactly what the statute meant. On a very direct level, Mark, it's a little hard to claim ignorance, Mark. What'd you do, man? Mark admitted to posting YT's nude photographs and videos, the agent explained, and acknowledged that he had intended to harass and intimidate. Great. The district court instructed the jury to consider that past conduct only to determine intent. And it's like, the lawyer in me understands exactly what's going on at that point, right? Because we're like, 403, right? Prior bad acts. Okay. So at this trial, we're bringing in the past conduct. Okay. Can we bring in the past conduct? Oh, there's rules against bringing in past conduct. You know that. You know that. You can't just bring in past conduct for the hell of it. But there are some exceptions. And like one of them is, for example, to prove the improved lack of mistake, for example. So it's like, I didn't intend this to harass. I had no idea that my conduct would harass her. How was I possibly supposed to know this conduct could be perceived as harassing? I mean, it was just an innocent whoopsie-doopsie mistake. I had no idea this conduct would be seen as harassing. And it's like, well, that's really interesting because 4 years ago, you seem to be real well aware that this conduct would be viewed as harassing. You seem to know that 4 years ago, Mark. That's not fair. You're using my prior bad acts. Well, I'm using your prior bad acts to defeat your affirmative defense of I had no idea. Seems like you did have an idea, Mark. Seems like you knew, Mark. Yeah, we can use it for that. We're not using it to prove. We're using it for a very limited purpose. We're proving it to defeat basically your affirmative defense of I had no idea. No clue. We're using it for a very limited purpose. Go to hell, Mark. YT testified next. She described how her relationship with Mark had started and ended, that they had met when both were working for the same airline. They began dating in 2002. During the relationship, she shared intimate photographs and videos with him. In 2006, however, their relationship changed when she discovered that he was posting her photos and videos on pornographic websites, and he was surreptitiously recording naked videos of her. That might harm a relationship. That could be a problem. Again, the district court instructed the jury to consider the testimony only as it relates to state of mind. Fair. I had no idea this would harass. Well, I wasn't really happy about it in 2006, Mark. Kind of told you I didn't really approve of it in 2006, Mark. Wasn't super happy you were doing it. 14 years later, I had no idea. It's so hard to figure out why he was convicted. So very, very difficult to figure out why he was convicted. In 2007, she testified after they had ended their relationship, she again found images on pornographic websites. Again, that might be somewhat detrimental to the relationship, I would think. Confronting Mark, she asked why was he doing this and asked him to stop. She was humiliated and embarrassed and fearful she would be discovered. Mark was apologetic. Not that apologetic, it turns out. Nonetheless, YT explained to the jury Mark continued to publish the intimate content. Mark has a problem. Mark sued him and attained a civil injunction. I apologize. YT sued him and obtained a civil injunction. Though again he agreed not to post any more images of YT, he did not stop. I had no idea. I had no idea she was offended by this. I had no idea these images could be perceived as harassing or harming in any way. There was an injunction, Mark. Told you specifically and directly not to do this, Mark. What do you mean you didn't know, Mark? I think you might have had some hints, Mark. I know sometimes they say men can't take hints, but damn. In 2013, she found the images again. Oh, what a surprise. He didn't stop. In addition to the visual media, Mark had drafted accompanying stories that were very lengthy and lewd and sexually graphic. She finally contacted the FBI. Yep. YT then recounted for the jury that Mark had pled guilty in 2016 to cyber stalking. Yep. Yeah. Again, we're not using the prior bad acts to prove conformity. We're using prior bad acts to defeat your affirmative defense, which is permissible. Addressing him after the plea, she told him that this conduct caused her much emotional distress and fear and humiliation, and she contemplated self-deletion to make this go away. His response was he was sorry. Okay. I'm more embarrassed than you. I humiliated you. I caused you to be fearful. I've affected your social life. I affected your motivation to go to work. During YT's testimony, Mark moved for a mistrial. Why? Because it's not going well? The district court denied the motion, but reiterated it could only consider his past conduct only to decide his state of mind or intent necessary to charge crime, which is the exception in the law, right? So we gave the limiting instruction, right? We gave the limiting instruction. We're not using it to prove conformity. We're using it specifically to defeat a very specific defense, which is permissible under the rules. So we gave our limiting instruction. You're only to use this to determine his state of mind or intent. Whatever could he be thinking? Sometimes people say to me, well, how do you prove what's in someone's mind? Like, how do you prove what's in someone's mind? These are some of the ways you might prove what's in someone's mind. Oh yeah, I'm having some pretty reasonable conclusions about Mark's state of mind right now. I'm having some pretty beyond a reasonable doubt, reasonable conclusions about Mark's state of mind right about now. Yep, that works for me. Turning to Mark's 2020 conduct, YT testified that a family friend had come across her nude photographs on Reddit. Learning about them, YT felt instant fear and disgust and feared for her safety because her private and personal information was in these stories. And she feared that anyone could see that they could find her home or work. She became reclusive and paranoid and overprotective of her grandchildren. She has grandchildren? Damn, Mark. Mark moved for a judgment of acquittal, contending the government had provided insufficient proof to establish YT's substantial emotional distress and intent to harass. The court denied the motion. Lol. Why? There's insufficient evidence of my intent. There's insufficient evidence to prove harassment or that she was distressed. And district court's like, were you watching the same trial I am? Because I'm pretty sure there was a lot of those things. But okay, Mark. A jury convicted Mark, and the district court sentenced him to 60 months imprisonment, 3 years supervised release, and restitution. The court also revoked his supervised release in his 2016 and resentenced him to 12 months imprisonment relating to that. So 6 years. He appealed both the new conviction and revocation of supervised release. Yeah, Mark, about that, I'm pretty sure you're going to be spending those 6 years, but it's okay. You only have to serve 85% if you're good, and then 3 years supervised release. Yeah, Mark, yeah, it's not. Mark, you're going to prison, Mark. Let's let the Fifth Circuit Court of Appeals explain to you why you don't have a First Amendment right, Mark. Lord have mercy. Mark contends that 2261A2B, as applied to his conduct, violates the First Amendment because his internet posts were speech. The government doesn't contest that the posts constitute speech, but instead counters that they were unprotected speech, defamation, speech integral to criminal conduct, and obscenity. Yeah. We reviewed as applied First Amendment challenges de novo because it's a legal question, right? We're not concerned about the facts anymore. We're concerned about, given the facts the jury found from their conviction, like we know what the facts are. We know what the facts are. The jury has resolved that problem for us. We know all the facts. So all that's left for us is to determine from anew whether or not, given all those facts, you're protected by the First Amendment. Do you think Mark's protected? I don't think Mark's protected. The First Amendment restricts the government from punishing speech outside a few historic and traditional categories of expression long familiar to law. Such categories of unprotected speech include defamation, speech integral to criminal conduct, and obscenity. We first consider whether the speech constitutes unprotected defamation. The familiar elements of defamation are false and defamatory statements concerning another, unprivileged to a third party, fault amounting to at least negligence, and either actionability of a statement irrespective of special harm or the existence of special harm caused by the publication. The speech was false. Yeah. He claimed, see, this is the problem. He wrote it as YT. That's not good. He claimed YT had authored the post, though she not. Well, that'd be a false statement of fact now, wouldn't it be? These statements were written by YT. No, they weren't. He wrote, for example, I'm a real U.S. airline flight attendant. Here, I shared clothed and naked pics, G to R rated home videos, and erotic stories for you to read about my exhibitionist fantasies. He also falsely called her an addict and an exhibitionist. YT testified that upon discovering her naked photos and videos, she was humiliated in 2007. This guy is just special. He's been around for a while in her life. Damn, man. Discovering the videos in 2007, she was humiliated and embarrassed by this and fearful she'd be discovered. She said that after court proceedings following his 2016 conviction for the same conduct, she wanted to self-harm to make this go away. And after she discovered the 2020 post, she instantly felt fear and disgust that opened the wound again. She became reclusive and paranoid and hid under a baseball hat. This is not the reaction of an addicted exhibitionist. Yeah. And like, even if she were an exhibitionist, that really only gets you so far, Mark, because she would be choosing what to expose or not. And so, you know, when you take that choice away and you're doing it for the purpose of harassing, you know, even if she were an exhibitionist, that only gets you so far. So, yeah. Mark's speech was also defamatory. He imputed unchastity, which is defamation per se, classically, to YT by conveying she freely shares naked pictures and videos with the internet, inviting men to look at her when she flew, and suggesting she would strip and self-pleasure herself for them. Holy shit. His speech also concerned YT. He insisted the Reddit post could not be linked to her, but the images and videos showed her face. Yeah, you know, that's going to be a bit of a thing. Okay, there's no way that anyone can figure out who these posts are about, except for the fact that I'm showing her images, videos, describing her profession, where she lives. I think we can figure it out, Mark. I think our massive big brains might be able to put two and two together, Mark. I think we might be able to tie this to her, Mark. He signed the post with her real maiden name, real occupation, real employer, and real state of residence. Yeah, those might be some clues, Mark. There's no way to possibly tie to her except that we used her photo, her name, occupation, employer, and state of residence. No way to figure out who we're talking about, though, Mark. People could and did link the post to YT. No shit. And as Mark admits, YT discovered the post because the family friend alerted to her after recognizing her in them. So the family friend was able to figure it out, Mark. His speech comfortably satisfies the remaining elements of defamation. He published the speech to a third party when he posted the internet. He knew the statements were false because he made them up. And his speech was actionable without special harm because it's defamation per se. Because it speaks to her chastity, which is defamation per se. So we don't need special harm because it's relating to her purity, which is defamation per se. So damages are presumed as a matter of law. So go F yourself, Mark. Jesus, Lord Mark. Because Mark's speech constituted unprotected defamation, the application to his speech did not violate the First Amendment. We need not decide whether it was integral to criminal conduct, which it absolutely 100% is in every possible sense, or obscenity, which who knows? Is it obscene? I don't know. Obscenity analysis is actually pretty tight. But this is absolutely integral to criminal conduct. So, like, I mean, that for me is the easier lift than the defamation, which is saying something, because the defamation is pretty solid. I'm not saying the court is wrong. I'm just saying of the three, for me, the easiest lift is integral to criminal conduct. It is obviously directly integral to criminal conduct. Are you insane? Right? In defamation, I actually had to do some analysis about it for a second. So of the three, I think that, they picked, I think the integral to criminal conduct was the easiest lift, but, they went with defamation, which, fine. That works too. Mark contends that 2261A2B is unconstitutionally vague. Lol. Because it fails to define substantial emotional distress or clarify when the conduct is reasonable to cause distress. No, Mark. No, Mark. It's not vague, Mark. No. It doesn't say what it means, substantial emotional distress. It doesn't say. We can figure it out, Mark. We reviewed de novo facial challenges of the constitutionality of the statute. Under the proper procedure for analyzing a vagueness challenge on its face, we first determine whether the statute reaches substantial amounts of constitutionally protected conduct. No. If it does not, we then consider whether the statute is impermissibly vague in all of its applications, or close to all. Right? That's the thing, right? Okay, does it cover constitutional conduct? Clearly no, there's no right to harass. That's dumb. All right, so is it vague in all? And they say all, but the case law seems to caveat that a little in my reading of the case law. So all can be put with a little asterisk. So maybe not strictly speaking all, but maybe nearly all, like almost all. Okay, so is this vague in almost all applications? Like, is it some sort of hyper niche application where we want to understand what this means? Like, it's so unclear, but maybe in some hyper niche situation, we can figure it out. No, Mark, this isn't hyper niche, Mark. We know what we're talking about, Mark. These concepts are known to law, Mark. You're a pervert, Mark. You're a very bad pervert and very bad person, Mark. Dark King Astos says, how does one define reason? Well, if you mean reasonable, we define reasonable as we define it as to the ordinary man, for starters. The reasonable man test is always a good place to go. So if you're like, okay, what does it mean for it to be substantially harassing? What does that mean? Or what does it mean for something to be reasonable? Like, a very good place to start with such questions is the reasonable man test. The reasonable man test, the normal, ordinary, prudent person, the ordinary, normal person of normal intelligence and normal station. The everyman. What would they think? Would this be something that would be, harassing to them? Would they find this problematic? Would the everyman, the normal, ordinary person of normal, ordinary education, the man on the street, the man on the bus, what would they think? And that's basically what reasonable is. Or any of those terms. So the reasonable man test, as always, gets you a long way. So it's always a good place to start. Yeah. Where's this reasonable test from? The case law. It's ancient as shit. It's ancient as law. It's old as dirt. It's well established in law. The reasonable man test is old as dirt. It's been around forever. It's been around so long that it has other names in other countries because it's so long, right? It's the reasonable man on the bus is what we call it in the United States. It's the reasonable man on the bus. If you go to Wikipedia, you can look it up. And in the UK, it has a slightly different name. It's like the reasonable man on the... and in Australia, it's like the reasonable man on the Bondi train or whatever bullshit, right? It's been around so long that the UK, US, and Australia all have the same test, but with slightly different names because it's been around so long that, it's been adopted by those countries. So it's been around for a hot minute. No one's confused by this. It's been around for a hot minute, man. Yeah. Reviewing court should establish the complainant's conduct before analyzing other hypothetical applications of law, because it's a party who engages in some conduct that's clearly proscribed, which is forbidden, cannot complain of the vagueness of law as applies to conduct of others. Yeah, no, right? So is there an as-applied challenge to be had somewhere? Probably, right? Is this unconstitutional relating to somebody? Maybe, right? Maybe it's unconstitutional as to somebody, just not you. Right? So like if you're trying to do a facial challenge, it's like unconstitutional to everybody. No. Is there someone for which this is unconstitutional? Maybe, but we can deal with that on a case-by-case basis. That's an as-applied challenge. So maybe there's some situation as applied that would be unconstitutional. This is clearly not it, Mark. Clearly not Lark. Yeah. The rule makes no exception for conduct in the form of speech. It does not. Because Mark does not contend that 2261A2B is unconstitutionally overbroad, we turn as to whether it's vague. No. Substantial emotional distress is easily understood. Citing a Ninth Circuit case, establishing substantial emotional distress is not esoteric or complicated term. A familiar term of tort law, it certainly is. Welcome to IIED and NEID. Right? Intentional infliction of emotional distress, negligence infliction of emotional distress. We understand these ideas of substantial emotional distress. These are not vague concepts, and these are not like unclear concepts. We know what we're talking about. A familiar term of tort law, emotional distress passes under various names, such as mental suffering, mental anguish, mental or nervous shock, or the like. It includes all highly unpleasant mental reactions, such as fright, horror, grief, shame, humiliation, embarrassment, anger, chagrin, disappointment, and nausea, citing the restatement of torts. Yeah. So the term reasonably expected. Indeed, we've explained that potential vagueness is not created, but instead is constitutionally remedied by the inclusion of the reasonable person standard. See, I told you the reasonable person standard was going to fix it. Now uncivil law gets to do a happy dance. Because uncivil law answered it 2 paragraphs before the court did. So uncivil gets to do a happy dance because they feel smarter. That's the uncivil law happy dance. Yes. The reasonable man test. The reasonable person standard. It solves many, many problems. It's great. Under these definitions, 2261A2B clearly prescribes, which is to say forbidden, Mark's conduct. He posted YT's nude photographs and videos after she had gone to great lengths to stop him from posting. Facts. Those photos and videos, some of which he captured without her permission, exposed her breast, vagina, and buttocks in sexually charged poses. Some of them showed her self-pleasing. Her face was visible in most. Alongside those pictures and videos, he appended stories that invited men to look for her when they flew, suggesting she would strip and self-please herself for them if they winked at her. Guys, if that isn't harassing, I don't know what is. If that isn't harassing, I'm not sure what is. Hi, my name is Cindy. Well, her name's not Cindy because it's YT, but we'll call her Cindy. Hi, my name is Cindy. I'm an airline stewardess. If you wink at me, I'll please myself for you. Please come find me on the flights. I'd love to. Yeah, if that's not harassing, I don't know what the term is, man. I don't know what the term is. We're gonna have to amend the legal dictionary to put a picture of Mark's face next to the term harassing. What is harassing? See Mark. That's it, man. That's the guy. That conduct alone would be reasonably expected to cause YT to experience substantial emotional distress. You think? But he also identified her to the world by signing the post with her real maiden name, real occupation, real employer, and real state of residence. It beggars belief that by using YT's maiden name, he effectively eliminated the possibility that she would discover his post and thus experience any distress. Uh-huh. He was 65 to 67 when he did this. I didn't know what his age was. It didn't say in the case what his age was. It just said that she was a grandmother, but we didn't know the case didn't say how old he was. But if he was 65, I'm not sure what that says about anything, but damn. Anyways, pressing on. As Mark acknowledges YT's family friend followed his post, identified YT and them, alerted her to them. Because 2261A 2B clearly prescribed Mark's conduct, he cannot complain of the vagueness of the law as applied to him. It says it in the news article. I believe you. It just wasn't in the case. So, I mean, I don't disbelieve you. It just wasn't in the case. And I just read the case. So he was 60. He was 65. Holy shit, Mark. Mark complains that the district court allowed YT to testify about his prior bond conduct. That said he violated Rule 404. I think I said 403 by accident earlier. I should have said 404. So thank you to the court for correcting me, because I said 403 and that was the wrong rule. 404 was correct. Thank you, court, for correcting me. That, he said, violated Rule 404, constructively amended his indictment, and violated his right to avoid double jeopardy. No, Mark. We review a district court's admission of evidence under Rule 404 for abuse of discretion, which means basically go to hell. This review is necessarily heightened in criminal cases. Evidence of another crime, wrong, or act is not admissible to prove character. But the evidence may be admissible for another purpose, such as proving intent. So we can't bring it in to show that you're a bad person. We can bring it in to show your intent. Go to hell, Mark. Reviewing Rule 404B challenge, we must first determine that the evidence is relevant to an issue other than character. Next, we must determine the evidence possesses probative value that is not substantially unweighed by its undue prejudice. On the second prong, we consider the government's need for intrinsic evidence, the similarity between intrinsic and charged offense, the amount of time separating the offenses, and the court's limiting instructions, in addition to the overall prejudicial effect of the extrinsic evidence. And that last part would be 403. Like the prejudicial effect would be 403. Substantially more prejudicial than probative. Is this substantially more prejudicial than probative? Lol, no. Lol, no, it's not. Fuck you, Mark. The government offered YT's testimony to establish Mark intended to harass or intimidate. Mark does not contest that relevance. Well, that'd be really hard, Mark. And contrary to Mark's suggestion, it was not unduly prejudicial. No, it's really not unduly prejudicial. It's kind of the exact same thing. It's the exact same woman on the exact same charges, because you got a problem, Mark. The government needed YT's testimony. It would have been helpful. I mean, for sure. I mean, it's probably necessary. She's probably a necessary witness, yes. She recounted fear and humiliation she suffered each time Mark had posted her intimate images in prior years. She told the jury how she had begged him for years, sued him, and even reported to the FBI to stop him. She thus established that Mark was aware of her agony, and more importantly, how she would suffer again if she published the photos. The government could accordingly prove that Mark intended to disturb YT persistently, torment as trouble with cares, bother continuously, pester, or prosecute her. Yeah. In addition, YT's testimony helped dispel the myth that Mark concocted at trial. Oh, this will be good. He said he had no idea that YT would ever see the pictures, and thus he couldn't have intended to harass her. That's dumb. That's really dumb. Even if that was true, it would be dumb. Even if YT had never seen the photos, it would still be dumb. Because he's explicitly inviting people to come up to her and say, basically, do this for me. So even if she had never seen the photos, it would still be harassing. So that's really dumb, Mark. These are all stupid arguments. But testifying that she had found the naked images online every time they published them, I'm sure someone would bring it to her attention eventually. YT demonstrated that Mark knew she would again find them when she published it. I mean, yeah, probably eventually someone's going to let her know. He protests that the agent had already testified about Mark's 2016 guilty plea for past conduct, and thus the testimony was superfluous. No. The agent read from the plea agreement, which merely recited the legal elements of the offense. The district court's limiting instruction further reduced any prejudicial effect. Repeatedly during testimony and before deliberation, the court stressed the jury could only consider Mark's prior conduct to determine his intent and state of mind. The district court did not abuse its discretion. No shit. Mark says the district court constructively amended his indictment by allowing YT to testify about his pre-2020 similar conduct. He presses that the jury convicted him of his prior conduct. No, Mark. We reviewed de novo a claim of constructive amendment of an indictment. A constructive amendment may occur when the trial court, through its instructions and facts, permit evidence, allows proof of an essential element of a crime of an alternative basis provided by statute, but not charged in the indictment. Well, that's not what happened. That did not happen. Yeah, no shit. Because the district court instructed the jury it was only to consider the crime that was charged in the indictment. Mark's 2020 indictment in turn charged him only for the 2020 course of conduct. And the court carefully stressed repeatedly the jury was to consider only facts as it bore to his intent. No, Mark. No, Mark. Mark claims that YT's testimony allowed the jury to convict him again for his pre-2020 conduct, which he'd already been convicted. No, Mark. No, we're not convicting you again. We're using it as evidence of your intent for the new crime to show that you were aware of what you were doing and intended it. No, Mark, we're not convicting you again. No, you did a new bad thing, Mark. You have a problem, sir. He argues that violated the double jeopardy clause, he says, because it forbids duplicative prosecution of a defense for the same offense. We review a claim of double jeopardy de novo, but the introduction of relevant evidence is not the same thing as prosecution for that conduct. It sure isn't. Double jeopardy is therefore not implicated. No shit. Mark contends the evidence was insufficient to allow a reasonable jury to conclude he intended to harass or he caused her emotional distress. Reviewing a verdict for sufficiency, we ask whether any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt. Any reasonable jury. Could any reasonable jury convict you? Yeah, I think they could have, Mark. We review all evidence in the light most favorable to the government or to the verdict, which is kind of the same thing, with all reasonable inferences and credibility choices made in support of the jury verdict. So that is true, and we've just discussed this before. It is innocent until proven guilty is over. Innocent until proven guilty is over. You were found guilty. So now we're going to view all the evidence against you. All inferences, all credibility choices will be determined against you. You're no longer innocent until proven guilty, sir. You're guilty. So now everything will be held against you in the worst possible light. Good luck. The jury had sufficient evidence, you think, to conclude Mark intended to harass or intimidate. Each time he posted her nude media in prior years, she discovered it. A rational jury could conclude he expected that she would also learn about the posts. Or, even if not, that people would come up to her and, want a little tug action, and that might be a little bit distressing to her. They could also conclude that, for example. Likewise, because he knew the humiliation and fear she had suffered in the past years, a rational jury could conclude he expected to cause the same result this time too. The jury could thus conclude that he intended to disturb YT persistently, torment as with trouble or cares, bother continuously, pester, persecute, or make timid or fill with fear. Pretty much, yes. Yes, he was sentenced. 6 years, we discussed. A rational jury could also conclude they intended to harass her by sending strange men to her. He invited readers to keep an eye out for YT while flying on her airline. Who knows where a suggestive wink will lead? You could get a sexy striptease from a pretty Latina flight attendant who, after an erotic nude dance, will lie back and spread her legs. Holy shit, Mark. Holy shit. Resisting that conclusion, Mark says his posts were not directed to YT. They were posted in a form that allowed the alleged victim only to find out when a close victim provided the link. But the question is whether any rational trier of fact could have found the requisite intent, and yeah. Mark offers that the government presented insufficient evidence to show she suffered emotional distress. Uh-huh. To begin, a jury could convict if found that Mark's conduct was reasonably expected to cause severe emotional distress, even if it didn't cause distress. Right, because that's the nature of the thing. Like, even if it didn't, it still was intended to, and that's the thing. And a rational jury could conclude Mark's conduct was reasonably expected to cause such distress in YT. As we've recounted several times already, Mark published her nude photographs, masturbation videos, and exhibition fantasies to internet forums. He signed them with her maiden name and told readers her occupation and employer. He invited men to look for her when they flew. People could link the post to YT. She found out about them from a family friend. Regardless, a rational jury had enough evidence to conclude that Mark's conduct constituted substantial emotional distress. When YT saw the 2020 post, she immediately started searching for them and spent 8-9 hours a day scouring the internet to find these images to see how bad this was going to be again. Seeing the pictures brought her instant fear and disgust. She feared for her safety because her private and personal information was in these stories, and she feared that anyone could find her home or at work. She became reclusive and paranoid, covering her face under a baseball hat and not wearing makeup. Overprotecting her grandchildren. Holy shit, Mark. She controlled what they could wear and who could photograph them. These posts disturbed her so much she contacted the FBI. Yeah. Any emotional distress that YT suffered suggested Mark was caused by her previous posting for which she'd already been convicted. For support, he posts to YT's testimony she felt instant fear and disgust that he opened the wound again. And he says he had reason to believe that reposting these images may not cause substantial emotional distress. Really, Mark? You really thought that? I don't think so, ma'am. This is dubious, says the court. I'm beyond dubious. I'm incredulous. I'm well beyond dubious. I'm incredulous. But we ask again whether a rational jury could have found beyond reasonable doubt this course of conduct caused or is reasonably expected to cause distress. The answer again is yes. Okay. Mark posits the district court erred by refusing to give his proposed jury instruction. We review the district court's decision to give or exclude a jury instruction for abuse of discretion. A court abuses its discretion when it refuses to adopt a defendant's suggested jury instruction that is substantively correct, not substantially covered in the jury charge, and concerns an important part in the trial, so failure to give it substantially impairs the defendant's ability to present an effective defense. A district court does not err, however, if the jury charge tracks the Fifth Circuit pattern instructions and correctly states the law. That's one of the reasons we have the pattern instructions, so we don't have to do this every time. Mark complains that the court erred by refusing to award his preferred instruction on intent. He wanted the court to say the government had to prove that the defendant intended to harass the complaining witness as opposed to being motivated by some other reason, and that Marks intended the specific result. He complains the court instruction allowed the jury to convict even if he had only intended the post, but not intended to harass or intimidate. But Mark suggested instruction was substantially covered in the jury charge, even if it deviates slightly from the pattern instructions. The court instructed the jury it needed to find that he acted with intent to kill, injure, harass, intimidate, or place under surveillance with intent to kill, injure, harass, or intimidate another person. Contrary to Mark's fear, a jury could not convict if it found he intended only to post. He also laments the district court refused to award a second limiting instruction that, he said, would have clearly delineated the jury could only convict for acts occurring between May and September of 2020. But the desired instruction was also substantially covered in the jury charge. The court stressed that Mark was not on trial for any other conduct besides the charge in the indictment. That indictment charged him from a course of conduct from on or about May 2020 to September 2020. And the court repeatedly instructed the jury during testimony as well as the charge that it could use Mark's prior conduct only to determine state of mind. The district court did not err in refusing the instruction. Mark also noticed an appeal for revocation of his supervised release from his 2016 case, wherein he gets an additional year. Having failed to brief the argument, he abandons and therefore affirmed, and all other pending charges are moot. So that is the end of Mark. That is the end of Mark Joseph Uhlenbrock. So 6 years plus 3 years supervised release. Mark has a problem. Mark has a very big problem. So, yeah. So Mark gets to spend the next 5 years in Club Fed with some supervised release thereafter. Mark is very, very incredibly guilty. Mark is insanely guilty of this crime and probably other crimes besides. But this was the one he was convicted of. So we'll leave aside. Also, of course, he might be charged under state law, and maybe he was. This is just the federal government, of course. He could have been charged as well under state law. So maybe there's a state prison sentence on top of this, or in addition to this. Who can say? But yeah. And again, it is quite possible that some of these revenge porn laws are not constitutional, either on their face or certainly as applied. Right? I mean, I don't know every single law of every single jurisdiction, and it's quite possible some jurisdiction somewhere has gone too far in its application. And it wouldn't surprise me. It would not surprise me if someday the U.S. Supreme Court strikes down one of these laws somewhere. But it won't be this law, and it definitely won't be today. So whatever can be said about the future of revenge porn laws more globally, not today. So that's pretty much the end of Mark. I have trouble not just putting this under copyright law. Copyright law is principally civil, and that doesn't have anything to do with anything. Copyright is not the issue. The issue is the intent to harass. It could also be a violation of copyright law. In addition to that, so there could be multiple laws it violates. So it could well violate copyright law too. But copyright law is principally civil. And and it also probably violates some other statutes as well. So yeah. His lawyer claimed this is an effective life sentence. Well, that's unfortunate, Mark. Maybe you shouldn't have done that then. Yeah, that's unfortunate. If you die in prison, then that was really, really unfortunate. So you shouldn't have done that thing. Yeah. And it's also, of course, civil for other reasons. It's also a civil violation for intentional infliction of emotional distress. It's also civil for defamation. So if we wanted to sue Mark, we've got plenty of grounds to sue Mark. I'm not sure that Mark has any money, but we could definitely sue him. Or more to the point, one of the reasons we could sue him is to sue him for any copyright that he would have. And then we could sue for the copyright and then, use that to like take down photos in the future using DMCA protection, for example. So there's some reason to sue for the copyright, of copyright of any photos that he would have the copyright to. And so we could get the copyright of those as a civil judgment. That'd be one thing to possibly secure. Did I see your message in Discord? No, not particularly. About the case my aunt is petitioning with. I tend not to try to read cases that are personal like that, so I probably won't read it. If you want cases that touch you personally in some way, I'd recommend contacting a competent lawyer in a relevant jurisdiction. But I don't want to give individualized legal advice. That's not really what I do. So anyways, I'm going to go ahead and sign off for now. I hope you have a great day. And till later, my friends, have a good one. Bye for now.